My name is Jeff Morgan. Continuing on with that last video that I stopped after talking about the father's, how the petitioner wants the father to be ordered by the court to attend classes and because he has a transgender or a potentially transgender child. There is no diagnosis for this, but nevertheless, this is what she is asking the court to do. The petitioner is also ordering that the father produce the following. She wants the father's 2016 and 2017 federal income tax returns with all attachments. She got rid of him, and now she wants to have these documents. It makes no sense. She should have no right to them. She wants all year-end pay information for 2017. She wants all payroll stubs, vouchers, commission checks, and records of commissions and all written records or evidence of income received by the respondent from any source, including but not limited to 1099s, K-1s, W-2s, extension requests for the period beginning January the 1st, 2017 through the date of production, and she wants a financial information sheet in the form attached hereto. Moreover, she wants the respondent to pay reasonable interim attorney fees and expenses. Well, fortunately, that was denied. But can you imagine just asking a judge the audacity to say, I want you to order my neighbor to give me his tax returns or her tax returns? And all of the evidence of income that he or she has. But this is the intrusiveness of the courts. And this is the intrusiveness that takes place whenever a situation of divorce or annulment takes place. This is why I've said on many occasions, no-fault divorce encourages the expansion of government. No-fault divorce and similar things like that actually increase the size of big government. And just so that we're clear, our current governor, Governor Abbott, has encouraged this in the past. No matter what he talks about with small government and stuff like that, as the Attorney General, he would have been fully behind this. This is horrendous that parents who often did not want to even go through a divorce or an annulment are being discriminated against, and that their private lives are being intruded upon by the government and the courts because somehow the state has the best interest of the children in mind. In addition, there are permanent orders, permanent injunctions that the petitioner is requesting from the court. So these are the permanent injunctions that Ann Georgelis, the pediatrician from Coppell, Texas, is asking for. She is asking for a permanent injunction enjoining the respondent from cutting the hair of the children. The father is never, ever allowed to cut the hair of the children. Never allowed to take them to a barber shop. That is what she is asking for. Number two, she is asking that the respondent, Jeff, be kept from signing up Luna, and again, Luna is the fake made-up name, prevent him from signing up Luna as James, and James is his legal name, for any activities, or taking her, and again, her is really a he, from taking him as James or calling her James. Again, James is his legal name. He is a male, but she wants the court to enjoin Jeff from calling his son James, his legal name, and from referring to him as a boy, which is his biological sex. And furthermore, from using any male pronouns related to Luna at any activities outside the home, including but not limited to school and extracurricular or school activities. Number three, she is asking for the court to order that the father be enjoined from allowing the children to remain in the presence of anyone, who is not calling Luna by her chosen name, Luna, not using female pronouns to refer to her, and otherwise not affirming Luna. So if Jeff and I were out at a restaurant, and if I said, hello, James, to his son, and I've never met his son, either one of them, but if I were to say something like that, Jeff would have to turn to me and say, Mr. Morgan, you cannot do so. I forbid you from doing so. You may not do so. You may not call this boy James, James. You must call him a girl, or her, or she, and you must call him, her, Luna. But it gets even more interesting because there was another document that was filed by a motion for an ex parte temporary restraining order against Mr. Younger. And in this one, the petitioner is asking the court to dispense with the issuance of the bond, but she wants the court to temporarily restrain Mr. Younger immediately without hearing. No hearing, no due process, based on her word alone, and you would be shocked at how many times these things are given by the courts. No due process, no hearing, nothing. One person comes, says something to the court, that person can be lying, and the court will act on that person's wishes. And should the person who may not even know about it, could be arrested for this later on. But here is what she is asking the court to do. She is asking the court, without hearing, and after notice and hearing be temporarily enjoined, pending further court order of this court from, number one, from letting him come within 500 feet of the child's school, which is Pinkerton Elementary, until further order of this court. Number two, wants the court to stop him from talking or having any contact with any third party related to the school. That would be parents, students, teachers, administrators, etc. Could be counselors, could be janitors, until further order of this court. And number three, taking any action to notify any third party related to the school, parents, students, teachers, administrators, etc., that the gender of Luna is different than a girl named Luna. Again, this is the motion for ex parte temporary restraining order. Now, here is the affidavit of Ann Georgelis. And by the way, all of this stuff is available online, so this is nothing secretive. It's all been public. Yes, it does contain some sensitive information, but it is all available on a public website. And the affidavit of Ann Georgelis, MD, pediatrician out of Coppell, Texas. She states that she is the petitioner in this case, and she is requesting that the court order an emergency ex parte temporary restraining order against respondent Jeffrey Damon Younger, Jeff, based on the following facts. Number one, after several hearings in this matter, Judge Beecham issued temporary orders on 8/3/18, August 3rd, 2018. Judge Beecham. Now, when I first saw his name, I thought his name was pronounced Beauchamp. Beauchamp, Judge Beauchamp, but it's actually Judge Beecham. Judge Beecham has ordered these things. Listen to what he's ordered. Specifically, Judge Beecham ordered that the hair of James/Luna is to be worn in a manner that is normal for both a 6-year-old boy and girl. Parties must obtain permission of the amicus attorney and follow the instructions of the amicus attorney regarding haircuts of the child. You cannot get your child's hair cut except if you go through an amicus attorney. This is the order from Judge Beauchamp or Judge Beecham. This is what the state of Texas thinks that they can do. They are completely violating parental rights, completely. This is according to the way I read the Attorney General's opinion, KP 02-41, issued February the 22nd of 2019. That's the Attorney General, Ken Paxton, for the state of Texas. But that's okay. These judges will not be deterred. They will still continue with these orders. Number three, the first possession that Jeff had after entry of that order, so the judge ordered that nobody should cut the hair of the child, Mr. Younger had the weekend of August the 17th through the 19th. Jeff cut Luna's hair. Now, wait a minute. Again, Luna is a fiction. James is his legal name. Luna's hair was already fairly short boy cut, but was cut even shorter. So the father cut James' hair. Number four, Jeff did not get permission from the amicus attorney to cut Luna's hair. Number five, Jeff knowingly directly violated a court order by cutting Luna's hair without the permission of the amicus attorney. This is what these courts will do. And this is all based, by the way, on the Texas Family Code, that wonderful Texas Family Code that gives the court such permission. If you wonder why I call it the Texas Anti-Family Code, now you see some of the reason. So furthermore, the judge ordered that the parties are mutually enjoined from taking any action that results in embarrassment or humiliation of the children. So if you have your son with you and somehow you're taking him out as a son and somebody says, well, isn't that Luna? Oh, that's so embarrassing. Well, that is forbidden. So the judge is ordering the father to accept that his son is not a boy. This is horrifying. It should be horrifying to everybody in the state of Texas. This is the politics of sex being played out. The politics of the LGBTQ community. The politics of transgenderism. There is nothing scientific behind this. This is a pure political power grab. B, addressing the children in any manner that embarrasses or humiliates the children. So again, if you call your son James or a boy, or why don't you give it to him, give him the ball, that could be potentially embarrassing. And Judge Beecham has ordered that nobody should be allowed to do this, neither parent. It's always interesting though how, basically this is designed to tell the father, don't humiliate the child, but what if the child is humiliated by being called a girl by the mother? Nah, there's nothing about that in there, is there? This is all directed toward the father. And C, taking any action to notify any third party that the gender of James/Luna is different than the child's appearance before the third party. So I want to talk about sex and gender for a moment here, because a child is born with a sex. Actually, at birth, the child's sex is recognized. The sex takes place at the moment of conception. Gender is something which is a social construct. So, and this has been argued in front of the court. I've got to watch the entire thing. When a child is born, the child has no gender. The idea of gender is a combination of the child's thoughts about himself and interaction with the society and the culture around him. Based on these things, he develops a gender. Now, it may be a more feminine gender, it may be a more masculine gender. The interesting thing is, you might be a female gender in one culture, but you go to a different culture and it may be a different gender. So you may be a transgender here, but not a transgender over there. That's the way that the whole gender ideology works. And the important thing, according to the politics of sex, is that you do not care about the physical plumbing or the chromosomes of the person. You must care only about their identity, their gender identity. That's what you must affirm. So if you call a boy a he when he wants to be called a she because he is perhaps maybe even living in a delusional state, being surrounded by wrong people, well, now you could be guilty of a crime, as what happens up in Canada. Anyway, she also accuses the father of bullying and engaging in directly and indirectly in behavior that is shaming and embarrassing. And then there is an event coming up on August 30th, 2018. There is an event at the Pinkerton Elementary School. It is curriculum night. So a father and a mother, parents can go to the school to find out about the curriculum that the school is going to use to teach the children. She does not want Mr. Younger to go to this. He is a father. He has the rights to see what his child is going to be learning, from whom, what type of curriculum is being used. But she is trying to get the court to tell him he is forbidden from going. He has voiced his intention of attending this event. And her pleading is this: I am genuinely concerned that Jeff will intentionally embarrass Luna, the made-up name, and talk to other parents and try to inform them that Luna is, quote, his son. Well, he is his son. And that he has 2 twin boys, James and Jude. Well, he does have 2 twin boys, James and Jude. Luna has only attended Pinkerton as a girl named Luna. That's because the mother has the sole and exclusive right to educate the child in accordance with what she sees fit. So she enrolled him in school. She enrolled her in school with the name Luna and told the administration that the boy is actually really a girl. And this is, for 2 years, this has been going on. And if Mr. Younger engaged in any of these actions that would embarrass or humiliate or notify a third party that James is actually a boy, this should not happen. The judge has already ordered that this should not happen. So a letter was sent to Mr. Younger, who promptly ignored the letter. And if that's all he did, I commend him for his self-restraint. There are some other things that he supposedly did to which I say, right on. He had every right to respond the way that he did. I am very concerned, continues with Ann Georgelis, that Jeff will continue to violate the orders and try to, quote, out Luna at the event on August 30th, 2018. This would cause immediate and irreparable damage or harm to her and damage. It might force her to even want to change schools. This would not only hurt Luna, it would hurt Jude as well. Let's talk about Jude for a moment. Here is a twin boy, and he's got his brother, and he's got to tell everybody that his brother is a girl. Do you think that creates any type of stress for Jude? Do you think it creates any type of moral confusion? Do they realize what's happening in Jude's mind? Have they asked Jude, Jude, how do you feel about this? Knowing that you were born a boy and your brother was born a boy, but now you have to call her a girl. If Jude's saying, is this going to happen to me? Am I a boy? Am I a girl? Am I going to become a girl? What's going on here? But of course, there's really no regard for Jude in this situation. To continue, Palmer and Manuel, this is a Texas law firm, and this was written by Kim M. Meters, is also talking to Mr. Younger's attorney and trying to reminding Mr. Younger's attorney that if Mr. Younger were to do such things, they would be in violation of Judge Beauchamp's or Beecham's orders. Specifically, the judges, the parties were mutually enjoined. Judge Beauchamp or Beecham made the order that both parties should refuse from taking any actions that result in embarrassment or humiliation of the children. They should address the children they should not address the children in any manner that embarrasses or humiliates the children. They are enjoined from taking any action to notify any third party that the gender of James/Luna is different other than the child's appearance before that third party. Now, the other interesting thing was they showed a video. The attorneys for Ann Georgelis showed a video of James wearing a dress and James dancing in a dress. As a normal person, I took a look at this and I said, what's wrong with the parents? Something was wrong here. They showed pictures of him with boy clothes on, and you're like, this is the way it should be. But you see him with a dress or something in his hair, and the first thing you think is, what is wrong with these parents? Mr. Younger is against this. Dr. Georgelis is for this. And she's trying to, by socially affirming her son, she's preparing him to end up receiving puberty blockers, sex change hormones, which he would have to take for the rest of his life, which would cause sterility, which would cause a lot of other issues, including, according to the research that these great experts presented, a shortened lifespan in most cases by 20 years, a much greater risk of suicide, and a host of other problems that they say you cannot do this. The risks far outweigh any rewards. At the very least, let it play out for the next 10 years. Do not socially affirm them. When you start socially affirming them, you make it more likely that they will undergo this medical treatment. And by the way, Rebecca Orr, who is the licensed clinical social worker, I believe what she is designated, is all for this. At least it would appear from that based on the correspondence. I will continue and wrap this up in just a moment. Thank you.